Richard Roper, former United States Attorney of the Northern District of Texas. Thank you so much for joining us. So the U.S. Justice Department, as you know, filed the most serious charges yet in connection with the attack on the U.S. Capitol January 6th, 1 year ago. So what is seditious conspiracy and how serious is it?
Well, it's a very serious offense. And the charge is very, very broad. It's essentially any kind of act which is termed seditious to interfere with the lawful order or process of the United States. As you can imagine, that could include many, many different things. Here, it's specifically dealing with a conspiracy to prevent and obstruct the lawful transfer of power, and that being the certification of the election on January 6th, and then the lawful transfer of power on January 20th.
And is it fair to say that they were trying to, I mean, is it too much? Is it an overstatement to say they were trying to overthrow the government?
Not overthrow the government. They specifically focus in on the two acts being the a conspiracy to essentially obstruct and hinder the certification of the election on the January 6th. And then ultimately, after that, the conspiracy continues to prevent the lawful transfer of power when Biden took over on January 20th from Trump. Those are the key elements of the charge.
And this is very rare, right? I mean, these charges you don't see these charges all that often.
No, and there's many times you can get charged conduct that's not as provocative. And there are other charges that are less provocative that are normally charged in situations when you have what is normally called obstruction of justice. But here they step forward and charge the sedition conspiracy, which captures other conduct that in many times you could parse out and look at an overt act or an act the government alleges in furtherance to the conspiracy, and you could look at it in isolation and you might say, well, that's only really someone voicing their concern for the government or their feelings that something is not legitimate. But they use that conduct, those communications, to say that was an act in furtherance of a conspiracy to essentially obstruct the lawful transfer of power.
You reviewed the indictment for us, and I really appreciate it. What stood out to you?
Well, I think what they've taken is the government's the investigators and prosecutors have taken a lot of time and hard work to pull together encrypted communications and other acts that they see are done in an effort to further this conspiracy to prevent the lawful transfer of power. For instance, gathering ammunition, gathering weapons, formulating a plan to enter the Capitol, formulating a plan to prevent the transfer of power on January 20th. All of those they put in really detailed form about actions by the defendants to essentially achieve this goal. Gathering body armor, deploying members in stacks to enter the Capitol, also having a quick reaction force that actually had a cache of weapons outside of the Capitol, but ready to be deployed at the communication or direction of these oath keepers.
One of the things that his attorney said yesterday, Rhodes' attorney said yesterday, was that, hey, my client never entered the Capitol. But when you look at the indictment, he was on the Capitol grounds and was directing, according to the indictment, was directing other people into the Capitol. So Does it matter that he didn't enter the Capitol?
Well, he's charged with conspiracy, and a conspiracy, you don't actually have to commit a substantive act. You just have to conspire with others. And he could be outside the Capitol and still be a member of the conspiracy. It is interesting to note that they specifically set out some communications in the indictment. And one of the communications between some of the members is uh, specifically stating, do not bring weapons into the Capitol. And those weapons were going to be deployed with the quick reactionary force. So, uh, it's kind of a mixed bag. There's some awful communications talking about civil war, and then there's some less provocative comments that are included in the indictment. It's kind of a mixed bag.
Do you think that helps them when they said not to bring weapons in the Capitol, or no?
Well, I think if I were a defense attorney, I'd certainly raise this. Obviously, people don't may not. It's obvious from looking in the indictment that those oath keepers, for right or wrong, thought that the election was illegitimate, and they voiced their opinion. Again, whether right or wrong, they had a right to voice that opinion. The question is, what actions did they take? Did they take actions, essentially illegal and lawful acts, to essentially prevent the lawful transfer of power? That really was, and in the indictment, there are many provocative statements that are made, and also actions they took that would seem to look altogether that there was an unlawful conspiracy to essentially obstruct the ability of Congress to certify the election and then allow the lawful transfer of power.
And my other question is just based on what you said, as far as the things that they said, you know, as far as the Civil War comments, as far as hold on, let me get my notes here. That it'll be a if President Biden were to assume the presidency, quote, it will be a bloody and desperate fight. We are going to have a fight that can't be avoided. Um, when you look at that, and then some of the other things that were said, even on the night of the 6th, where Rhodes said, according to the indictment, nothing, that happened that day is compared to what's coming. How much of those, statements can get them into even bigger trouble and get them convicted? Or is it really, like you said, it's more of the actions than the statements?
Well, look, it's a conspiracy. So what unlawful agreement that these defendants have that they can prove, and there's certainly an argument to make that they have a First Amendment right to protest what they consider to be an unlawful election. But when they make statements that they're going to take action and commit violent acts, that belies that argument that they were just peacefully demonstrating. That's the problem that the defendants face in this case. And the FBI and the U.S. Attorney's Office and the District of Columbia have harvested very, very provocative comments that they made in apparently in encrypted and private communications that belie this idea that they were this up there to lawfully protest what they consider to be a illegitimate election.
And then the alleged actions as far as the buying of the body armor and the ammunition and weapons and then having that quick response force, etc.
Yeah, those are what in the terms of law they call overt acts, specific acts that are designed to further this unlawful conspiracy. And again, if they were in an effort to try to peacefully demonstrate, why bring up the body armor? Why bring up the batons? Why bring up the weapons? Why have a ammunition there if they were just there to lawfully protest? That is going to be tough for them to explain. And remember, these defendants will not be tried in the Dallas-Fort Worth area. one of the defendants is from Granbury, which is in the Northern District of Texas, federal district, but they're going to be tried in the District of Columbia. And I would think they're going to face, in my estimation, a hostile jury pool.
All right, Richard Roper, thank you so much.